Hello, everyone, and welcome to today's event on online platforms and common carriage rules, brought to you by the UCLA Institute for Technology Law and Policy, which is a new cross-disciplinary initiative dedicated to ensure that new technologies are developed and implemented in ways that are socially beneficial, equitable, and that support accountability. My name is Michael Karanikolas. I am the newly minted Executive Director of the Institute. We have an excellent slate of speakers today, so I will jump right into the introductions. Baron Soka serves as the president of Tech Freedom. Previously, he was a senior fellow at the Progress and Freedom Foundation. Before joining PFF, he practiced internet and communications law at Latham and Watkins LLP and Lawler, Metzger, Milkman and Kenny LLP. He clerked for a federal district judge and received his Juris Doctor from the University of Virginia. Eugene Volokh is the Gary T. Schwartz Distinguished Professor of Law at UCLA and the author of the textbook, The First Amendment and Related Statutes, and over 45 review articles about First Amendment law. He is also the founder and co-author of The Volokh Conspiracy, a leading legal blog. Jane Baumbauer is a professor of law at the University of Arizona. Professor Baumbauer's research assesses the social costs and benefits of big data, surveillance, and communications technologies. Her articles have appeared in the Stanford Law Review, the Michigan Law Review, the California Law Review, and the Journal of Empirical Legal Studies. Professor Baumbauer's own data-driven research explores bias judgment, criminal justice, and gender equity. She holds a BS in mathematics from Yale College and a JD from Yale Law School. We are planning to devote a little bit of time at the end to audience questions. So please enter those in the chat as they come to you. And that concludes our very brief housekeeping at the outset. Professor Baumbauer, I turn things over to you.
Great, thank you. Well, it's so nice to have this conversation between Eugene and Baron. I always learn a lot from them, and this is a topic that is sure to raise a lot of interesting issues and maybe squabbles. So we're here to discuss proposals for changing to some extent the CDA 230, the Communications Decency Act, Section 230, because right now that law, as many of us know, give platforms like Facebook and Twitter the advantages of publisher and the advantages of neutral conduits. So what I mean by that is like a newspaper, they have a lot of control and discretion over what types of content they remove. But unlike a publisher, they're not subjected to liability for defamatory speech and many other things. So this law has run into a lot of criticism, and the criticism goes in both directions. Some commenters want platforms to be doing much more purging in order to make content less provocative, less hostile, less misinforming, that sort of thing, while others want platforms to do much less purging in order to preserve some ideological neutrality. So we're focusing primarily on that latter category, the proposals that suggest that platforms should be more neutral and do less content moderation. Florida has already passed a bill prohibiting platforms from suspending or deleting accounts of politicians, and others have proposed a range of different types of restrictions that would require platforms to perform content moderation differently from how they do today. And Eugene, I want to start with you because you have your own proposal. So could you please summarize what you suggest the law should do or require for platforms, speech platforms?
Sure. So I'm not sure that the law ought to do more in this area. Very complicated question. I'm not positive what's constitutionally permissible, and I'm even less sure what's the right policy answer. Nonetheless, I think it's helpful to put out there as a possible thing to think about, treating social media platforms as to some of their features similarly to the way we treat common carriers, like phone companies, for example, or like UPS or FedEx. Now, of course, common carriers still have their own free speech rights. A phone company can express whatever views it wants, so can UPS and such. Likewise, a university can express whatever views it wants and mold its curriculum as it wants and such. But as to particular kinds of things, like, for example, decisions about whether to allow somebody to use the phone system for, let's say, Antifa propaganda or Nazi propaganda or something like that, the phone company is not allowed to block that. I mean, as a matter of private property rights in the first instance, it would have had the right to do that. It owns its lines, but because of common carrier laws, it's treated as a common carrier and required to treat, generally speaking, I oversimplify here, but generally speaking, treat all users equally and certainly without regard to the viewpoint they express. Likewise, let's turn to universities. Universities are not treated as common carriers as such, but in a case called Rumsfeld v. Fair, the Supreme Court said that it's okay for Congress to say to universities, you must allow military recruiters on campus on the same terms as you allow other recruiters. Of course, you still have your free speech rights. You have your right to express whatever views you want about the military. You also have a great deal of power, First Amendment protected power to choose, for example, your curriculum, to choose whom to invite to conferences and such when you've got speakers, a particular small set of speakers you're inviting. But when it comes to something like inviting recruiters, which you routinely do with very modest selectivity on your part, we could say you can't pick and choose. To give another example from a case called Pruneyard, shopping malls indubitably have First Amendment rights. They exercise them all the time, usually to express themselves commercially, but also they can put up Christmas decorations, they can put up Hanukkah decorations, they can put up pro-support our troops decorations. But if a state wants to say anybody who comes on to this widely open shopping mall is entitled to hand out leaflets and gather signatures, at least in those places that are open to the public. And the mall can't discriminate based on viewpoint among those people. That too is constitutionally permissible. So that's a model we have in one area. That's for things like, which I think are kind of platforms. The phone company is a platform, UPS and FedEx as delivery platforms, and places that own property like universities and like shopping malls. On the other end, by the way, we have things like newspapers and magazines, where I think indubitably the First Amendment protects their right to pick and choose what to publish, because they are publishing only a tiny fraction of all of the things that are potentially available, and they get to select within that. So the question is where social media platforms ought to fall. And I think as to their decisions about whom to host, not necessarily their decisions about what to recommend, like not necessarily to their decisions about how to moderate conversations, although that I think is a complicated question. But as to their decisions about whom to host and not to host, I think it's plausible, constitutionally permissible, and maybe, not sure, but maybe a good idea to treat them as common carriers. So that's the idea I want to lay out on the table and see what people think.
Okay, and Barron has been writing about this topic quite effectively, including on Lawfare. So before we go into sort of a more systematic analysis of the First Amendment's application to a proposal like Eugene's, Barron, do you want to just start by sharing your thoughts on why you think either this proposal is in broad strokes unconstitutional or a bad idea, or both?
Yeah, well first, this is not about 230. The starting point for this conversation is usually that 1996 law, but when it comes to content moderation, what Section 230 does is provide a civil procedure shortcut to the result that the First Amendment would have required. The First Amendment, as I will explain, protects a private entity's right to decide what content it will refuse to carry. And Section 230 says that you can assert that right as a statutory matter upfront when you're sued for decisions you make not to carry other parties' content. And in that sense, Section 230 doesn't change the common law. It does essentially the same thing that anti-SLAPP laws do. An anti-SLAPP law says that when you are sued for defaming somebody about a matter of public concern or who is a public figure, that you can get that lawsuit dismissed easily, as the First Amendment would ultimately require. 230 does essentially the same thing. So the debate here really is about what the First Amendment will permit. So for everyone other than Eugene and for a few academics, the people who are pushing the idea of common carriage are pushing this really because what they're really interested in, what they're really objecting to, is restrictions on hate speech and misinformation. This debate is really about whether we're going to have restrictions on that kind of speech in the United States. And of course, the First Amendment bars the government from imposing the kinds of restrictions that one would find in every other developed country in the world. And the American right has turned to the idea that it should use common carriage regulation to force social media sites to carry speech such as hate speech and misinformation, calls for another Holocaust, et cetera, et cetera. Now, Eugene is arguing good faith, and there are a few other academics who do so. And I think it's a testament to his intellectual honesty that he's willing to parse these issues as carefully as he is. And I would just note at the outset that actually he concedes that most of what the right is pushing for is barred by the First Amendment. I would say that about 80% of this debate, if not more, is about the thing that he recognizes is First Amendment protected editorial discretion, which is what kind of recommendations will a website make? How will it curate content on the site? What order will it appear in the feed? What recommendations are made as to users to follow and what topics are trending and so on. And Eugene is not talking about that. He's talking about applying common carriage concepts to hosting content, such as will Donald Trump's account appear on twitter.com, the ability to find those accounts, and then the ability to see their content, the content that you subscribe to, in an uncurated feed if you want to do so. This is much, much narrower than what is being proposed in Florida, Texas, and other states, where the issue is really about what has been called shadow banning and things like making recommendations or providing visibility, et cetera. So just at the outset, I just want to give credit to Eugene, but also note that the states that are actually pushing these ideas aren't interested in that kind of needle threading. And I would point to, in Florida, the fact that the law, on the one hand, explicitly excluded websites owned by Disney and Comcast because they own theme parks, while at the same time, the governor made very clear that the real purpose of the law was to retaliate against social media sites for removing content that conservatives claim is their own, and that claim that helps them. Now, I would also note that Eugene's distinctions, while they're, I think, theoretically interesting, start to break down pretty quickly in practice. So, for example, when he says that he recognizes recommendations as protected editorial discretion, but he wants people to be able to find the Volokh conspiracy when they search for those words on Twitter, I think in practice, I think he would actually recognize that what we're really talking about in that circumstance is search engines. Search engines, even to the point of you put in words on Facebook or Twitter to find an account, and then you get a bunch of results returned. Those are recommendations, and there is editorial discretion involved there. And Eugene has written quite eloquently about why that is protected by the First Amendment. And I would submit that when a user searches for the word Nazi on Twitter, it's really up to Twitter to decide whether they're going to recommend the Wiesenthal Center for Countering Nazi Violence or whatever, or the American Nazi Party. Those are recommendations. Those are editorial choices that these sites have to make. And similarly, then when you have this idea that one should be able to get an uncurated feed of users of all the content that you subscribe to, well, again, in practice, that's not really what people use social media sites for. But it's also very different from the sorts of things that he points to as being constitutionally permissible. So he says, for example, that in the Fair versus Rumsfeld case, that the government was able to compel a university to tell students about the fact that there were military recruiters on campus. And he says similarly that a website should have to tell its users about the Volokh conspiracy site or Trump's blog or the Nazi Party account or whatever. And I think those things are fundamentally different. I think the Fair versus Rumsfeld case tells us very little here because it's about what the court recognized as being conduct and not speech. And what we're talking about here are really expressive choices that are made by websites as to not just what content to recommend, but what content will appear on their site. And this is something they have historically done. And I would note that Prodigy was held liable back in 1995 for user content because precisely because it had said things like the following: "We make no apology for pursuing a value system that reflects the culture of the millions of American families we aspire to serve. Certainly no responsible newspaper does less when it chooses the type of advertising it publishes, the letters it prints, the degree of nudity and unsupportive gossip its editors tolerate." That is exactly the same thing that social media have done and continue to do, and they do it across the board, and they are held accountable by the marketplace, by users, by advertisers, not merely for their recommendations, but for the content that they post. They are not able to distinguish themselves from that content merely by posting disclaimers. And you can ask Twitter how well that worked when they tried to do that last year before they banned Trump. They tried to post disclaimers, and of course that was decried. And as a constitutional matter, you can't compel them to try to separate themselves from that speech. And then I know I've gone long, but I just will close by noting two final points. One, what we're talking about isn't really neutral. It discriminates among speakers. These laws inevitably pick and choose which sites they apply to, and singles them out for special burdens. And then even facially neutral non-discrimination requirements would have clearly disparate political effects. And I go back here to the reality that the American right is pushing for these concepts of a common carriage precisely because they want certain kinds of content, specifically hate speech and misinformation, to be carried. So I don't suggest that that's Eugene's motive, but I think the courts will be smart enough to sniff through the motive that is putting these laws forward. And then finally, common carriage regulation seems like a tool that would be useful here, but that's not traditionally what common carriage regulation is about. At common law, common carriage regulation was about holding yourself out to the public as serving everyone indifferently. And indeed, the Communications Act since 1934 has essentially implemented that distinction in the very functional, complicated definition that it's parsed. And we don't have time to get into that right now, but I will just note that when Eugene says that phone companies are common carriers, we'd be more precise to say that telephony is a common carrier service for important functional reasons, that it connects users directly and does not involve editing, while text messaging is not a common carrier service. And the same reasons for which text messaging is not a common carrier service help us to understand why social media, which connects many people, not necessarily in real time, and with editing in the middle, is also not a common carrier service. And it's because of these distinctions that the common carriage regulation we have for communications has avoided First Amendment scrutiny in the past. Most notably, broadband was held to be a common carrier by the Obama administration. And ultimately, when the DC Circuit reviewed that and was forced to confront First Amendment arguments made by then Judge Kavanaugh, the DC Circuit was able to say, well, that's not an issue here because these rules only apply to broadband services insofar as they hold themselves out as providing an unedited service to everyone. And of course, that's not what social media do. What we're really talking about here is something radically different. It is compelling social media to change their historic role of deciding what content they carry and instead to carry all speech.
Okay, so there's a lot on the table. Eugene, I'm going to give you a minute to respond to whatever you want to, and then I'll have a couple more specific questions, I suspect.
Sure. So there's actually much of what Barron says that I agree with. But the one thing that I think is unhelpful there is just to focus on the politics. It's true. It's the right these days in politics who is most interested in dealing with social media blocking of ideas, in part because they're the ones who perceive themselves to be aggrieved. They're the ones who think that they're out of step with the ideology of the social media companies. If you look, by the way, you'll see it's not just the right, it's just that smaller group on the left. People who are on the relatively far left, socialists and others, have also objected to social media platforms engaging in what they describe as censorship. And it's probably unsurprising, Barron mentioned, well, except for a few academics, but they're not just any old academics. Erwin Chemerinsky, one of the leading liberal academics in the country, indubitably a man of the left, has spoken out in favor of a governmental power to regulate social media in this respect. Likewise, Genevieve Laquire, a young scholar at University of Chicago, and Nelson Tebbe at Cornell have also spoken out about that, in part because the left has long recognized, and by the way, I think smart people on the right have also recognized this, maybe put different weight on it, but have always recognized that at some point, private corporate power, and it could be private individual power too, but it's usually, they have that kind of power, you've got to have a corporation, can become as much of an intrusion on the marketplace of ideas, or not exactly as much, but at least at a comparable level as at least some forms of government power. That was the basis, by the way, for the dissent that Justice Stevens wrote for the 4 liberal justices in the Citizens United case, where they thought that corporate power is such a serious problem that corporations shouldn't even be allowed to speak about candidates. Now, I disagree with him on that, but I do think that he has a good point about corporate power there. And when it comes to corporations blocking others from speaking, that's something that perhaps at least we should be more concerned about corporate power there, less concerned about any First Amendment rights of the social media companies, because again, they're free to speak. The question is whether they should be able to block others from speaking on their services. So I think this is something that people on the left and the right should think about, in part because, you know, things change so quickly when it comes to the nature of these kind of private actions. Today, it may seem like the restrictions are coming from the left, but, you know, there's nothing inherent in large corporations that suggests that they will always be in favor of the liberal perspective. It's unsurprising that people, especially on the pretty far left, on the anti-corporate left, are worried, rightly so, about their speech being restricted as well. So I'm less interested in the ideology behind all this, and I'm more interested in what makes sense as a more general proposition.
Okay, well, that leads us too nicely into the first question I wanted to ask about the First Amendment for both of you. Those on the maybe the far left that are nervous about the corporate power that can be wielded in this space might have often characterized at least some of the platforms like Facebook and Twitter as being quasi-governmental in terms of their in terms of how fundamental the access to their platforms are. So is there any decent argument that that Facebook or Twitter satisfy the state action requirement? Yeah, I see.
We can settle that pretty quickly. I do not think so.
All right, and I take it Barron.
What can Congress do if it wants to do to establish a statutory right of access? I do not believe there's a constitutional right of access, because I do not believe that they are government actors.
Okay, and Barron, you agree with that?
Completely. Halleck makes this very clear. What makes someone a state actor is fulfilling a traditional and exclusive state function. Hosting the speech of third parties, as the court said in Halleck, is not such a function.
Okay, all right, good. So there's agreement on that. So what can the legislature do is the main question. Okay, so let's dive into then the disagreement about the scope of Rumsfeld, and understanding maybe from both of you why Rumsfeld is not the appropriate analogy, or you know whether Rumsfeld is the appropriate analogy to this type of a forum.
So I talk about three cases: Pruneyard, which dealt with public access to shopping malls; Turner Broadcasting, which dealt with broadcast stations' access to cable systems; and Rumsfeld, which dealt with military recruiters' access to universities. Now, all three of them involved some government-created rules. Sometimes a statute. In Pruneyard, it was a California state constitutional rule, but for our purposes, it's the same as a statute. So that was the source of the right of access, not the First Amendment. The question is whether the First Amendment blocked that right of access, whether the property owners could say, hey, our property, we are speakers too, certainly cable systems are, certainly universities, that's what their business is speaking, including by selecting speech. And the court in all three cases, in Pruneyard and in Rumsfeld, unanimously says, well, the government could require at least certain kinds of rights of access. And in particular in Rumsfeld, which I mentioned just in part because it's the more recent case, it's only about 15 years old, the court says, look, we know universities are really, by the way, Rumsfeld involved a funding condition, but the court said this law would be constitutional. In fact, the whole reasoning was this law would be constitutional even if it were a mandate. So that's why I'm going to treat it as a mandate, because the court treated it that way. So the court says, look, we know that you universities don't want to have military recruiters on campus. In this case, it was because, generally speaking, because the universities opposed the military's don't ask, don't tell policy as being discriminatory based on sexual orientation. So we know that you find this to be hateful, you find this to be offensive, and you're perfectly free to speak out against it. But that doesn't give you a First Amendment right to say we refuse to have it on our property. What's more, not only might you be required to have it on your property, you would have to also treat these recruiters equally with regard to certain kinds of speech of your own. Basically, you want to think of kind of directional speech, like you the military recruiter is in this room from this time. You can't say, okay, we'll let him on campus, but we're just not going to pass along information about where he is. Likewise, if there's a printed list of all recruiters, you might need to write down, you might need to speak the name of the recruiter and the location and the time right there on that list. It seems from the record in the case, the same would apply that if there's a hiring fair, like a bunch of people together in a large room, each one at his own table, you'd have to include recruiters at that table. Now, of course, the court, you can't require a university, for example, in its class, in a course, to teach a certain view about military recruiting. You can't require a university-run newspaper or newsletter to include articles in favor of military recruiting. So a line has to be drawn between these kinds of situations where the university is essentially being used as a platform for the speech of others, generally speaking in situations where the university basically takes all comers, not necessarily, of course, it wants to exclude somebody, but like, for example, with recruiters, basically, if you are a recruiter, you want to show up, generally speaking, you're entitled to. In that kind of relatively non-selective situation, the court has, in Pruneyard, in Rumsfeld, has allowed the government to say you have to also include some people you don't want to include. And yes.
Well, can you explain then how that would apply to what Barron described as your distinction between the recommendation function,
right,
protected, versus, he brought up an interesting idea though, that if you're looking for Volokh conspiracy specifically, there's still a search function, which I take it would you categorize that then as directional?
So that's a great question. And I do think it's not an easy line to draw. And maybe on balance, you'd say the line is so hard to draw, let's just abandon this whole project. Again, I'm quite tentative about this. But it's a line that Rumsfeld seems to authorize, and a line that we use in other contexts, I think, as well. So let's say, for example, that the university, following Rumsfeld v. Fair, said, okay, fine, we're going to allow military recruiters on. But when somebody asks us, where can I find the military recruiter? We're going to say, we won't tell you. Or we're going to say, oh, you're trying to use us as a search function. So we're going to refer you to Lambda Legal, public interest advocacy group that backs equal rights regardless of sexual orientation. Because we think they're the ones who have more interesting things about military recruiting. Say about military recruiting. I don't think Rumsfeld would give them a First Amendment right to do that. Rumsfeld does suggest that for certain kinds of factual information about how to get to a particular speaker, because remember, recruiters are speakers, how to get to a particular speaker, where to go, what time it's available, has to be included. So I'd say something similar, some similar line needs to be drawn for when I go to Twitter. And yes, if I search for American Nazi Party, I mean, if I search for, is the Holocaust real? Maybe I think Twitter ought to be able to point us to sites which seem to express the consensus that it is real. On the other hand, if somebody is searching for American Nazi Party, and it is something that is understood to be the kind of search box that people use primarily as directional information, that seems to me to be like this asking for directions to recruiters. Again, not a trivial line to draw, but one that I think Rumsfeld contemplates. Obviously, if I go to the university and say, what do you think about military recruiting? They're entitled to say, oh, the real people to talk to about that are Lambda Legal. But if I say, where is the military recruiter showing up tomorrow? Then under Rumsfeld, I think they can be required to say, well, he's in room 127.
Okay, so in a minute, I'm going to ask Barron how Rumsfeld would apply to online platforms, or if it's to be totally ignored. But first, I want to press on you a little bit, Eugene.
Sure.
Does that mean that Congress could require Google to change its search results when it's obvious that someone is trying to get to a specific website, like the Nazi Party website?
So I don't think so, although again, I think that this is a line drawing question. So I should say up front, I wrote a paper, this was commissioned by Google on First Amendment and search engines, arguing that search engine results are protected by the First Amendment. But I feel I can say that wearing my academic hat, it's also something I'd stand by as an academic. And again, if we look at the Rumsfeld v. Fair, that really, for the overwhelming majority of the kinds of questions you might ask the university has to have First Amendment rights to say, here's our answer. like university. Did the Holocaust happen? Well, you know, if we decide, if let's say there's a research library desk at the university library, yes, the answer is yes. University, what do you think about the American Nazi Party? I think the university ought to have the right to say, you know, some universities may say, you know, it's not our job to take stands on even questions like that, to say, well, we're against it. Every First Amendment right to say that. On the other hand, if the university again is asked, where do you go? Or where do I go if I want to meet the JAG Corps recruiter tomorrow, then they have to give a specific answer. So I think, again, a line has to be drawn. I think when it comes to Google search results, that is something that where the whole point of that is to take a vast universe of information and then deal with that information overload by prioritizing that. Google search results would be useless if they weren't content-based and even viewpoint-based in certain measure. So I do think that that is protected by the First Amendment. On the other hand, when it's not a question of dealing with this vast information overload, but just what room is the recruiter in, I think that's something that, well, we're pretty sure from Rumsfeld that's something where the university doesn't have unlimited First Amendment discretion. And I'd say the same if the question is Twitter. What's the Twitter feed for Eugene Volokh or the American Nazi Party or whatever else?
Okay, Baron. So how do you square Rumsfeld with online platforms?
Yeah, so we just spent several minutes discussing how to apply to the facts of social media an exception to the general rule. I don't think the exception applies. All of the cases that Eugene has mentioned are exceptions to the general rule set forth in Hurley, which involved a parade organizer, where the court said the fundamental rule of protection under the First Amendment is that a speaker has the autonomy to choose the content of his own message. Now, the question in each of these cases is the content at issue the message of the speaker? So that's why these are exceptions. And Eugene's argument is that in all of these cases, and in the case of social media, that the content that these services host is not their own speech, that they are not providing an expressive service, there's no expressive unity. These are, to quote a line from Hurley, individual unrelated segments that happen to be hosted together for individual selection by members of the audience. Actually, I think that's from Turner. But that's in a nutshell, that's one side of this debate. The other side of this debate I will set forth, which is that each of these cases is easily distinguishable on their facts. In Rumsfeld, the court upheld the requirement that schools host military recruiters because recruitment, it held, was conduct, not speech. And to the extent that there was speech involved, the speech was, quote, plainly incidental to the Solomon Amendment, which is the law, to its regulation of conduct, and involved only, quote, compelled statements of fact, unquote, about the time and place of recruiting meetings. Moreover, it was very clear that no one would confuse speech on campus with the speech of the university itself. And in that sense, Rumsfeld relied upon Prunier to make exactly the same point, that no one was likely to mistake the shopping mall's opinions or to confuse those with the speech that was being posted on the grounds. And the court continued that the owner would be free to disassociate himself from those views and was not being compelled to affirm a belief in any governmentally prescribed position or view. Similarly, in Turner, which involved whether cable companies could be compelled to carry broadcast signals, the court said, given cable's long history of serving as a conduit for broadcast signals, dating back to 1969, there appears little risk that cable viewers would assume that the broadcast stations carried on a cable system convey ideas or messages endorsed by the cable operator. That is the unifying theme in all three of those cases. And here, Eugene and I think, disagree on the facts. He thinks that no user reasonably assumes that the content that they would find on Twitter is the choice of that site. Now, again, we're distinguishing between the recommendation function and then whether you see content on there. But I think just the opposite. I think, for example, that if I look at CNN.com and I read a news story in which CNN includes screen capture of content on Twitter or an embed of a tweet from the American Nazi Party or Jared Taylor, these are actual users who have been banned from Twitter. If I were to read such a story, And so I'm not seeking that content out, but if I were to read such a story and I see that that content exists on Twitter, and I think the vast majority of people today, and certainly advertisers, I associate that content with Twitter. I believe that Twitter has made an editorial decision to allow that content on the service. And in this sense, whether I'm right or not, the bar is set very low in all these cases. The court repeatedly said, there's no risk, it's not going to happen, there's no evidence that anybody holds the shopping mall responsible, et cetera, et cetera. But in fact, I think the court is quite willing to recognize that users, speakers of all kinds, platforms, have a right not to be associated with content. And in that sense, the compelled speech doctrine serves two functions. One is that these services cannot be compelled to speak in terms of including content in the overall product that they produce, just as a parade organizer cannot be compelled to include that content. And I will note that in the case of Hurley, the court actually made the point that I made just a moment ago. It says, rather like a composer, the parade organizer selects the expressive unit of the parades, and though the score may not produce a particularized message, each contingent's expression in the organizer's eyes comports with what merits celebration on that day. But then the court adds, but even if this view gives the organizer credit for a more considered judgment that it actually made, the organizer clearly decided to exclude a message it did not like from the communication it chose to make, and that is enough to invoke its right as a private speaker to shape its expression by speaking on one subject while remaining silent on another. So the two forms of compelled speech here, the two ways in which a site gets to remain silent are, one, not to have that speech be part of its content, but then secondarily, not to have to be in the position where the Nazis are marching in the parade and the parade has to run a truck by it saying, this is not our speech, we are not responsible for it. Similarly, social media cannot be put into the position of having Donald Trump on the site and then having to post disclaimers. And that's for good reason. Those disclaimers embroil these companies more in the culture wars. That's clearly what happened when Twitter tried to do that. They were lambasted for it by very people saying that Trump should have remained on the site. And of course, that content itself is speech that they have a right not to engage in. If they want to decide that it's just better not to have Trump on their platform, they have that right. And the three cases that Eugene cites really are readily distinguishable on their facts when you look at how people perceive social media, what they hold social media accountable for. And most of all, this is not just the users, but advertisers. Advertisers do not want their products shown either next to or on a site that is associated with such content.
Eugene?
I could speak a little bit about this. So first of all, just to make clear, Rumsfeld was not resolved on the theory that military recruiting is merely conduct and not speech. That would be a strange theory because recruiting is all about speech. You can imagine like when you actually offer someone a deal, sign up for 6 years and sign on the dotted line, maybe that's treated as a conduct of entering into a contract. That's not the description of most recruiting. What the court said there was that the law, the Solomon Amendment, regulates conduct, and the conduct is the university's exclusion of recruiters. So the law can ban that conduct and say you can't exclude military recruiters. And then this university can't turn around and say, well, we're speaking by this exclusion. So I think the analogy is pretty close. It's just that the university was using or the question was whether its real estate could be used in order for people to speak. University is a speaking organization. It uses its real estate mostly to speak. The question is, could it be required to allow its real estate to be used to speak? And for platforms, it's the virtual estate, right? It's a pretty, we think about, it's on the platform. It's like a mall in some respects, like a university and its property. So I don't think Rumsfeld can be distinguished that way. Likewise, let's look at what Rumsfeld actually said with regard to this possibility that somebody might confuse the recruiter's message with the university's. Rumsfeld did say, nothing about recruiting suggests that law schools agree with any speech by recruiters. I think that's just a judgment of what a reasonable person would perceive it. I'm sure that there are lots of people who complained about it and who thought that universities, if they didn't exclude recruiters, would be implicitly approving of them, not necessarily agreeing, but at least obviously being willing to allow them on their property. Usually when we see that somebody is voluntarily allowing a speaker on their property, we at least associate that person with the speaker. So there's some possibility of that. But the court concluded that again, despite what I think this obvious possibility that there'll be some connection, that's not enough. And the court says nothing in the Solomon Amendment restricts what the law school may say about the military's policies. So the court was saying essentially was, look, if there's some possibility that people might be confused about it, very easy for the school to dispel that confusion by putting up a disclaimer. What's more, the court says, we have held that high school students can appreciate the difference between speech a school sponsors and speech the school permits because legally required to do so pursuant to an equal access policy. So the court's view especially is not before the equal access policy, but once the equal access policy is in place, would people really assume that the fact that the university is allowing somebody pursuant to the law, pursuant to a legal obligation, would people really assume that is endorsement? They're simply following the law is endorsement. Or would people, like the high school students in that precedent the court was referring to, be able to appreciate the difference between speech that the platform sponsors and speech that the platform permits because legally required to do so pursuant to an equal access policy? The court's view in Rumsfeld was pretty clear that yes, people could appreciate it. And if a few people say, no, we're unaware of this equal access policy, we refuse to hear about the equal access policy, we're just going to assume that because, contrary to the law, this hypothetical new law, we're going to assume that because when Twitter has something on its site, that means that Twitter endorses it as opposed to being legally bound to that. If that's people's assumption, the court in Rumsfeld is telling us that doesn't count for much in the First Amendment analysis.
If I may, I think it's important really to drill down on the facts of Rumsfeld, because this is really the heart of our disagreement. The conduct at issue in Rumsfeld was making a room available on campus for representatives of the U.S. military to come and recruit students, right? And then the speech at issue, well, as Eugene has been saying, was making sure that law schools tell their students what room to go to. I think we can agree on that. I think that is radically different from what we are talking about in the context of social media. We're not talking about a room in which private conversations happen. We're talking about whether someone like Donald Trump is going to use the site in the same way as every other user as a platform for speech. And the problem that I think Eugene has not confronted is that the reasonable perception of users is that when they see a tweet, in whatever context, whether that's on twitter.com or they see it embedded somewhere else, or they see it in a screen capture on Instagram, and that they see that is happening on Twitter, they believe that content reflects an editorial judgment by the site. Now, Eugene may think that is unreasonable.
Or, well, he thinks it's malleable, right? So if there was a law requiring them to host everyone.
Well, we can't avoid these First Amendment problems across the board by simply saying that the law compels it, right?
But that's what Rumsfeld said.
Yeah,
right.
Because in that case, there was no risk of association, and the burden on the school's speech was incidental. It was you have to tell them two things. All the school has to do in positive speech is tell users which room to go to, and second, the school itself would not. The activities that went on within the rooms in the campus was not part of an overall expressive output, but that was not the speech of the school, right? That is, I think, distinguishable from a service that is in the business of hosting speech and decides which kind of speech it's going to host. In that sense, I don't see social media as being distinguishable in any way from a parade organizer or a newspaper, both of which have First Amendment rights to decide what kind of content to host. And Eugene offers in his draft paper a number of distinctions that he thinks are relevant. He says that there's no scarcity limited on social media. I don't think that's a relevant distinction. I think the importance of scarcity in other media is that in the broadcast context, scarcity of the airwaves meant that there had to be a government role in licensing particular users. And that state action fundamentally changed the First Amendment analysis. So it's not that scarcity matters in itself, it's that scarcity necessitated state action. Here, for social media, there is no state action. These are private actors making decisions about how to use their private property. And ultimately, the choice they're making is, what is the overall expressive output of our services? These services all promise, but dating back to Prodigy, to offer a place for kinds of conversation that they want to encourage. And they distinguish themselves. Prodigy distinguished itself from CompuServe. They offered a curated service where there would be less of defamation, less gossip than on CompuServe. That was their editorial judgment, and users held them to it. That's how they competed in the marketplace. And we now live in a world where the CEO of Facebook has to spend, in some cases, literally all of his time on earnings calls talking about these issues, about the content that is hosted on the service and how the service is going to deal with it. These are not minor issues that can just be waved away, and nor can we require these services to disclaim any responsibility for particular content, nor does a general law saying, well, you have to host it, nor does that solve the problem.
Okay, so this is great because it gets me back to a couple of questions I did want to ask Eugene. So the questions are related to whether you're really serious that that hosting functions can be legislatively required to be open to every sort of non-illegal, I guess, content. So would does your proposal really suggest that if the legislature wanted to, for some reason, it could require Facebook and Twitter to host nudity? Is there any limit to what could be required to be carried? And does that suggest anything about this hosting, the neutrality? Yeah, go ahead.
So I don't think there's any limit on what this legislature can require platforms to host. I think there are limits to how the legislature can do it. So to give an example, the people often ask, well, can the legislature require that Facebook not block the Nazis? Absolutely. Just like the legislature can require that phone companies not block the Nazis. If a phone company learns, oh, the Nazi party is recruiting using this line, they can't just say, we're going to cancel your phone line. Just in our system, that's not a decision for phone companies.
Okay, so then why is Facebook so different from any other smaller platform, like like a platform for knitters or something? So is it? Barron suggests that Facebook and Twitter from the start actually had their entire service was expressive.
Right.
I take it you see this differently, that it is actually, as a default, mostly neutral and only sort of nibbling at the edges. Is that right, or is there?
Well, so I think it's both. I think descriptively, Facebook and Twitter, at least when it comes to viewpoint regulation, setting aside the interesting question of spam, which is I think an important issue. But generally speaking, Facebook and Twitter, likewise with Google Gmail, let's say, they allow 95%, 99% of all viewpoints that are submitted. They block a small range of them, but on balance, it's very much a matter of we're going to allow most things with a few exclusions rather than the opposite, which is the way the New York Times works, right? The New York Times publishes a tiny fraction of all that it's required to publish. So that's, I think, just descriptively so, and it may affect the First Amendment analysis. If the question is whether Congress could regulate non-massive monopoly entities, and I use monopoly not in the antitrust illegal monopoly sense, but in the sense that they are in fact monopolies in their own particular important niches. So I think Congress could regulate beyond that. So for example, Congress, when Congress required universities to provide access to recruiters, it wasn't because universities are monopolies, they're hotly competitive. And in fact, many may compete with each other based on their ideology. Some of the universities did say, our ideology is of non-discrimination and of protecting people's rights to be free from discrimination. And that's why it's so horrible that you force us to allow these recruiters for this discriminatory institution. The court said, tough luck. So I think if Congress wanted to regulate a wide range of platforms, wanted to say, hey, WordPress, or not even WordPress, some other small hosting company You can't discriminate in hosting based on ideology, just like some other businesses may not be allowed to in some jurisdictions discriminate based on political affiliation and such. I think it would be free to do so. I'm not sure it's a good idea. It might make sense for the statute to focus only on those entities that have very substantial market power. It may be. But I don't think that, that the First Amendment somehow precludes Congress from imposing equal hosting rules on hosting companies. And again, the classic example would be like WordPress or something, which WordPress is very big, but there are lots of other entities that are much smaller.
Okay, Baron?
We are rapidly running out of time. This topic is far, far too complicated to squeeze into 1 hour, but I will just try to go through a few things. It doesn't matter how little content gets blocked. The court made this very clear in Hurley. I read that quote earlier. What matters is that these are services that have historically held themselves out as making editorial judgments. Eugene keeps saying phone companies can't block Nazis, but they can. The text messaging service is not a common carrier service, and all these companies that provide text messaging have every right not to carry particular content. Now the question is, could that be changed? That's under the Communications Act. Could that be changed as a First Amendment matter? And that, we don't have time to fully unpack that question, but I will just lay out for you that these questions are best addressed and best understood through Turner, a case we haven't really talked about very much about cable companies. What is, to my mind, most significant about Turner is, yes, the court upheld ultimately the must-carry requirement for cable to carry broadcast channels. But what is important is the cable companies, they objected to the intrusion upon their right to make money by choosing which channels to carry. That was the infringement on their editorial discretion. They never objected to the nature of the content they were being compelled to carry. Not once. It's not what the case was about. Moreover, the court made very clear that there was no evidence, no hint even, that there was any non-neutral motive or purpose involved, right? This case is readily distinguishable from both of those facts. These are, the objection here is precisely to the nature of hate speech, misinformation, and so on. It's not like Turner. And indeed, the services that are rejecting content here are doing so because they feel that they are being associated with the speech that they are being asked to carry. I keep coming back
And
to
they're
this.
pressured by their
That's
advertising.
exactly what happened in Rumsfeld v. Fair. Universities were facing pressure from students and from some alumni. Universities were saying this requires us to associate with institutions that we think are engaged in these evil policies. The universities certainly were objecting to the content in a way that the cable systems weren't. Yet the court unanimously gave them the back of the hand.
And as I've said, having someone use a room in your school and telling your students about it is not the same thing as having a public record of Nazis calling for another Holocaust on your site. And I think if one takes a little bit of time to go look at Parler and Gab, and one sees the content on those services, which one has to look for a little bit, but it is there, one understands what service, what good for society is accomplished, and also for advertisers by Facebook and Twitter actively removing that kinds of content because users do blame them for it. Okay, and at the end of the day, what we're talking about is these services being compelled against their will to host such content by, not Eugene, but by people who in general are pushing these mandates because they find this content useful. Now I started my remarks at this point, and I need to end with this because I have to explain why this matters. This matters constitutionally in terms of determining the level of scrutiny that is applied. Turner upheld must-carry mandates for cable because it applied intermediate scrutiny. And under intermediate scrutiny, the court said, okay, they have this gatekeeper power because of physical direct connection to the home. That's the exclusive bottleneck. That is a substantial government interest. We will uphold these mandates. But in a situation where the purpose of the law and the effect of the law is to compel services to carry the most abominable content imaginable against their will, and someone like Ron DeSantis makes very plain that that is his purpose. Just listen to his press conference. I'm not making this up. This is right there. They're making this quite obvious. Again, this is not Eugene's motive. I'm not ascribing this to him. But in such a circumstance, the court will apply strict scrutiny. And under strict scrutiny, there is no way that these sorts of mandates will be upheld.
Baron, you fault people who support these proposed mandates because you think they're just focused on promoting certain kinds of viewpoints. But here you yourself are defending the opposite position because you say we must ban hate speech. We must, or not ban, excuse me. We must have a legal regime in which hate speech is going to be suppressed. We must have a legal regime in which Nazis are going to be suppressed. Look, I don't like Nazis. The Nazis almost killed both of my parents. Few people like Nazis. And if I could somehow snap my fingers and have their speech vanish, that would be a wonderful thing. The bottom line, though, is that the First Amendment does protect Nazi speech because we think that on balance, it's a bad idea, to be sure, for the government to restrict speech this way based on viewpoint. So one question we need to ask ourselves is, when you've got this entity like Facebook, one of the largest, most powerful corporations in the country, do we want them to have now this power to decide which views are so evil that they're going to be blocked in a meaningful way for many users? Or do we likewise think that that's not a power we want those companies to have? That's, I think, a very important question.
And my position is not
your
that
objection is, if your objection is chiefly that you think we should so loathe the Nazis, which I do, we should so loathe the Nazis that we should have a particular legal regime that allows the platforms to restrict a lot more speech than just Nazi speech, then it seems to me you're engaged in the same kind of viewpoint motivated reason.
No, because first of all, this isn't just about Nazi speech. This is about whether children are going to be encouraged to eat detergent pods and whether people are going to be told lies about the election, vaccines, and so on and so forth. Second, this isn't about a legal regime that requires any of that. I'm not saying I want the government to have any role in this whatsoever. All I'm saying is that we do not get to decide whether private entities make these decisions. The First Amendment means that private entities get to make those decisions. And I am defending their right to do so against those who would pervert the First Amendment into a justification to compel them to host speech they do not want to host. That is what this debate is about. And the cases you're citing, I do not think are relevant to the situation of social media services that have to decide what content they will include in their overall expressive product, which they very much have in a way that is, yes, it is somewhat different from, but I think essentially similar to the role that is played by a parade organizer.
So in the Q&A, the one question we have, I'm going to sort of paraphrase part of it. It seems that what this debate really is boiling down to is whether we see platforms as serving mostly a sorting function where I, as a user, go to it because it is hosting, it is making certain choices about what it hosts, and not only what it curates, but also what it hosts, versus the assumption that the platform mostly hosts everything, and then the curation function does the matching to the end user. So viewed the second way, Eugene's take seems to make more sense. But is it possible, though, that that Baron and David are right that actually we are choosing, to some extent, we are choosing the platform because of what it chooses to host, and therefore any law that interferes with that would interfere with both the speaker and listener rights?
So I think we have to recognize that various entities have lots of different functions. So the university is overwhelmingly an entity for curating speech. Right? In the overwhelming majority of its functions, you do not want the university to be content neutral or even viewpoint neutral, right? You hope that the content of the curriculum is carefully curated. You hope that the conferences the university organizes are carefully curated, including often in viewpoint-based ways, like we'll invite people who represent a broad range of viewpoints, but not all possible viewpoints, among other things we can't. So in very many of its facets, universities are allowed to curate. In some other ways, they're not. I'll give you one example that we haven't touched on before. California has a statute that bans even private universities from instituting speech codes for their students. So that means that, for example, if it says we want to curate the environment by saying you can't wear MAGA hats or you can't wear Che Guevara t-shirts because he's a notorious mass murderer and it makes Cuban American students understandably offended. That would be illegal for it to do that. So that's an area where the university is not allowed to curate. Likewise, when it comes to curation that recruiting events that excludes the recruiters, then that's an area where it can't curate the speech in quite the same way. So I think likewise with platforms, there's no doubt that much of what people look for from various platforms is, what are the latest trending stories? That's what I'm interested in. I may want to focus in just the trending stories, be given the trending stories that are legit stories rather than total hoaxes, right? It's good. But other things, like when I go to twitter.com/Jane Bambauer, I don't know if there is a twitter.com/Jane Bambauer, but if there is, I'd like to go there. If I go there, that's what I'm looking for. I'm not looking for the curated version of Jane Bambauer's feed. I think I'm looking for her feed, generally speaking. And generally speaking, 99.9% of the time, I'm going to get your posts. Likewise, I think if I follow you, I'm expecting I'm going to see your posts and not Twitter's ideas of which of your posts I should be looking at because of their viewpoints. At the very least, I think that is a permissible distinction for the legislature to draw. Just as it says, we leave universities free to curate lots of speech, but not certain kinds, or so not certain kinds, excuse me, not in certain contexts, not as to recruiting, not as to what students can wear on their t-shirts. Likewise, it could say Twitter can be, and I think constitutionally has a right to curate what comes up in trending stories or whatever else, but can be blocked from doing that when people just say, I want to read this feed or I want to follow this feed.
Aaron, last minute for you.
There are a lot of functions, as Eugene notes, that these social media services break down into. We've been very focused on whether the user's account appears on the site. There's a lot more going on than that. There is that user's ability to interact with other users, to join groups, to participate on the site. And I speak from personal experience. I, for many years, ran the largest LGBT group for libertarians and conservatives on Facebook. I ultimately had to shut that group down because moderating that group became impossible because the service itself did not do enough to remove users who would use such a group to promote Nazi and other appalling ideas. I ultimately gave up trying to moderate that group. I use this example to convey that this is not as simple as the Bollock conspiracy, twitter.com/the Bollock conspiracy. This is about users interacting with each other, and to the point that David made in the question that he asked. What I wanted out of Facebook as a user was curation, fundamentally. I wanted Facebook to do more to remove the kinds of users who would share very thinly veiled fascist memes on my group. Because I couldn't manage the job of content moderation myself. It was too overwhelming to screen every user and every post and every comment that was put up on every post. That is fundamentally what we're talking about. It is fundamentally no different from enforcing rules at a bar. Who can come in, who can do what? And I will just note to conclude that even if you got common carriage regulation, you should ask what that actually means in practice, because traditionally innkeepers, for example, had every right to remove drunkards and people who were misbehaving. Moreover, there is a case law on common carriers being able to exercise their editorial discretion. Now, it was regulated. You had to justify that you were acting reasonably, and you had to say, for example, that you were removing all price advertisements within the yellow pages, and you were not doing so selectively. My point is simply that even under common carriage regulation, it's not actually true that a site would have to host everyone. It could, in fact, make rules. And I think, for example, the kind of rule that Twitter has made to say that they're not going to host political advertisements, that is exactly the kind of rule that a common carrier could implement. It could write that into its tariff, and that could be deemed to be applied consistently, and therefore would be upheld. So at most, what we're talking about in common carriage regulation, legally speaking, is subjecting that sort of decision-making to that kind of second guessing and ensuring that it's being done consistently. But it's never going to get the people who are complaining most loudly what they ultimately want, which is the right of forced carriage for the worst people in our society. Again, I don't ascribe this view to Eugene, but that is what's motivating bills like Florida's bill. It's very explicit. I'm not making this up. It is in the legislative history. It's in Governor DeSantis' statement. And I stand by my point once again that when these cases actually get litigated, the fine distinctions that Eugene is very admirably trying to draw are not the distinctions upon which these cases will be resolved. These will be struck down as non-neutral attempts to retaliate against the editorial judgments that are being made by private sites for their own private editorial reasons.
All right, well, that's all we have time to explore today.
Yeah, thanks so much to all three of you. That was a brilliant discussion, really fascinating. Before we go, I just want to leave you with a quick plug for our coming summer speaker series on global digital rights challenges, which will begin on June 17th with a discussion between myself and Faria Aziz on government internet censorship. So for further details, you can check out our Twitter at UCLA Tech, where details are to come shortly. Thanks very much to all three of our panelists. Hope everyone has a great rest of your day.
Thank you.
Thanks.
Great pleasure.